So welcome everyone. It's my great pleasure to introduce Dr. Khaled Fahmy, who will be, we didn't put up the title of your talk in our promotion here, but I will just read your biography and we will get into it.
Okay.
In addition to being a good friend for many years, Dr. Khaled Fahmy is a historian and is the Edward Keller Professor of North Africa and the Middle East at Tufts University. Fahmy's dissertation on the social history of the army of Mohammed Pasha of Egypt was published by Cambridge University Press under the title All the Pasha's Men. Muhammad Ali, His Army, and the Making of Modern Egypt, which was translated to Arabic and is considered a kind of a essential document on the history of Muhammad Ali's army. He's also the author of a biography of Muhammad Ali Pasha, Muhammad Ali from Ottoman governor to ruler of Egypt. His book, In Quest of Justice, Islamic Law and Forensic Medicine in Modern Egypt, came out in 2019 and won the 2020 Social History Society Book Prize. A collection of articles in Arabic on the history of law and medicine in 19th century that appeared under the title Al-Jasad wal-Hadatha al-Tibb wal-Qanun fi Masr, which is the body and modernity, medicine and law in modern Egypt, came out in Arabic. Fahmy has taught at Princeton, is where I met him, as at the American University of Cairo, where I just missed him. I was coming in and he decided to leave. And he's also the Capita visiting professor at Middle East Institute, Columbia University, the Shawaf visiting professor in modern Middle East history at Harvard University, and served as His Majesty Sultan Qaboos bin Saud Professor of Modern Arabic Studies at King College, Cambridge, UK. But then he's decided to come back to the States and has now been at Tufts for 4 years now? 5?
Yeah, this is my 4th year.
4th years. It gives me great pleasure to listen to Khaled talk. He's a wonderful talker, very intimate delivery of very essential information. I should also say that Khaled, I don't know if you're still doing this or not, but you were doing these long kind of YouTube sessions. A lot of them are commentary, a lot of them are delivering history. So it's become much more of a public intellectual after the revolution, discussing not only matters of historical matters, but also matters that are pertain to the situation in Egypt, and particularly since the army is very much part of the center of political life. But we'll leave that to another time, but is very much an available intellectual whose points of view on current politics and historical matters have become a essential reading to many people. So welcome, Khaled. We're glad you're with us.
Thank you so much, Khaled. Khaled and Khaled. Thank you very much. It's a pleasure and an honor to be invited to talk to you and to your colleagues and students. I cannot remember exactly the title of the series, but it has something to do with hidden stories and documents,
Yes.
Which is straight up my alley. This is something I've been working with, specifically in the Egyptian National Archives, and reading unpublished archival material from the 19th century. And I spent in writing this book, which you mentioned, Khaled, this book, In Quest of Justice. This is a labor of 15 years in the Egyptian National Archives. And I want to speak today about some of the documents that went into this book, and specifically about, and these are police records, police documents, the documents of the Cairo police and the Alexandria police from the middle of the 19th century. And also the records of courts, legal courts, and specifically of something that is called the Siasa Councils, which is what I want to talk about today. To give you an idea of what the documents look like, I am actually going to talk about this document. So this is a photocopy, obviously, but it is more or less the same size of the original. So imagine a register, a ledger, what they call a sigil or daftar, of that size, that thick. Each daftar would have something like 200 pages of writing. And I specifically worked on the registers of something called Majlis al-Ahkam, and I specifically worked on a series of this Majlis that has 317 registers covering a 35-year period from 1849 to 1879, 1880. And I'm going to talk about this document in particular, which goes on for 2 pages, as you can see here, 74 lines. And this is a photocopy of Majlis al-Ahkam. They're called Madbata. It's the minutes of a case, and it's a summary of a criminal case that pertains to the topic I want to talk about. I think the title of the talk is When Enslaved Men Sued Their Masters and Won. So this is a case from Majlis al-Ahkam, specifically from 1858, pertaining to an incident that happened to enslaved men in Cairo. So let me tell you the story the way it is written here, because one of the things that I am interested in is the narrative form, the narrative style. What kind of literary narrative techniques did the scribes who wrote these registers employ? And this is interesting also for linguistic reasons. This is 1858, before the novel started in the Arab world, before newspapers. So what kind of Arabic did this bureaucracy have at its fingertips? And specifically, what kind of Arabic did these scribes who are recounting criminal cases deploy? How did they tell the story? It's a whodunit story. And there are various ways of telling a story like this. So let me follow the narrative style of this document, the way it is recorded. The case starts by saying, we received the document, we Majlis al-Ahkam, and hopefully we will understand what Majlis al-Ahkam is. We received a document from the Cairo police saying that on a certain date in February of 1858, 27 enslaved men stormed into the headquarters of Cairo police, which was located in the northwestern corner of Cairo, in a neighborhood called Azbakiyya. This is the headquarters of the Cairo police, to give a deposition against a high-ranking dignitary, a bey. Bey is a title of a high-ranking dignitary, called Omar Bey Wasfi, who was employed in an estate daira that belonged to Ilhami Pasha. Pasha is even a higher dignitary, a term of a higher stature than Bey. Ilhami Pasha actually was the grandnephew of the ruler of Egypt, of all of Egypt, Said Pasha. he was also married, this guy, Ilhami Pasha, was married to the daughter of the Ottoman Sultan. So you cannot find a higher ranking. I mean, this estate is basically owned by a member of the ruling family. Not only a ruling family, but he happened to also be married to the daughter of the Ottoman Sultan. I mean, this is very, very serious indeed. Now, these 27 enslaved men are bringing a deposition not against Ilhami Pasha, but against someone working in his estate. This guy is called Omar Wasfi, Omar Bey Wasfi. The substance of their deposition is as follows. They say that this guy, Omar Bey Wasfi, had caused the death of one of their colleagues. Interestingly, the name of their colleague who had been killed, according to them by Omar Wasfi, is Sultan. So a slave called Sultan. Sultan got a permission from his master, Omar Bey Wasfi, his master technically is Ilhami Pasha. He is his master, he owns him. But the overseer of the estate, Omar Bey Wasfi, gave him permission, gave Sultan a permission to go to Cairo proper. Why? Because this estate is not in Cairo. It's on the outskirts of Cairo. It's in a place called Demirdesh, which now is in Cairo. Cairo has expanded significantly over these years. That this estate now is where the Coptic Patriarchate is. Those of you who know Cairo. But at that time, this was in the middle of the desert. It's like 2 or 3 miles away from this police headquarters. The geography is important because imagine what we're seeing here. Imagine the scene. These 27 enslaved men left their estate and marched in the middle of the desert all the way to Cairo proper to go to the Cairo police headquarters to give in this deposition saying that their master, Omar Bey Wasfi, had caused the death of Sultan. Why? Because Sultan 3 days earlier had been given a permission to go to Cairo proper for only 2 days. He didn't come at the end of the 2 days. He came a day later. So to punish him and to teach him a lesson, this overseer of the estate, Omar Bey Wasfi, decided to flog him, to use the kurbaj, the whip, against him. They say that Omar Bey Wasfi ordered Sultan to be lashed 1,500 lashes. And one of these men say, I know exactly the figure, 1,500, because I had a sibha, a worry bead, that had 99 beads in it. And I was counting the lashes, each lash with 1 bead. And every time the sibha made 1 entire circle, which is 99 lashes, I would extend a finger. By the end of the beating, I had extended my fingers 15 times. That is how I know that he was beaten 15 times. We were tired, because he ordered these enslaved men to beat Sultan, and they kept on, people were so tired that they had to exchange the beaters 3 times. By the end of the beating, Sultan was in a miserable state, and there is a very vivid description. I'll spare you the details, but suffice it to say that the skin was peeling off his back and his buttocks. Not only that, but Omar Bey Wasfi prevented Sultan from eating or drinking for 3 days until he perished. The 27 men also said in their deposition that we were afraid because this is not the first incident. In fact, Omar Bey Wasfi had beaten to death or ordered 2 previous enslaved men to be beaten in 2 earlier instances. And we are afraid that we may be next. Interestingly, these men ended their deposition by saying, we demand that the Cairo police commissioner come back to the state with us to investigate the case. And then they said, we also want the chief medical officer to come with him to investigate the body. And we made sure before leaving not to allow the other officials of the estate to bury Sultan's body because it's evidence. And we want the chief medical officer to examine the body. On hearing that, the Cairo police commissioner sent one official to go and arrest Omar Bey Wasfi. He failed. He sent another police officer, and there is an interesting encounter that I'll talk about later when the second person arrived at the estate gate. He asked to enter, and the chief of the black servants prevented that senior police officer from entering the estate. He told him, Ilhami Pasha, Omar Bey Wasfi is not on the estate. He left. So he told him, okay, I have a summons, piece of paper with the summons on it. The chief black head of the slaves on the estate refused to receive the piece of paper. And he said, this is not my business. And Omar Bey Wasfi is not on the premises. So that left the third attempt, this time by the chief of Cairo. The Cairo police commissioner in person decided to come to the estate to arraign Omar Bey Wasfi. He arrived at the estate only to see Omar Bey Wasfi escaping through the back gate. So he chased him in the carriage. There's an amazing scene I'm trying to imagine of 2 carriages in the middle of the desert, Ben-Hur like in the middle of the desert, 2 carriages, and ultimately the Cairo police commissioner jumped from his carriage to Omar Bey Wasfi's carriage, took him by the hand, escorted him to the Cairo police headquarters to start an interrogation, only to find the chief scribe of the estate coming with 2 purses of money in a blatant attempt to bribe the Cairo police commissioner. The Cairo police commissioner did not accept the money and ordered his own scribe to write down what had transpired, and this was an act of bribery. And then the interrogation started. Omar Bey Wasfi denied the charges. He said, yes, I ordered him beaten, but obviously not this excessive number. And these slaves, these are slaves. You're listening to them, you're not listening to me. They are drunkards, and they are knee deep in smoking hashish. The 27 enslaved men gave their individual depositions, and then the doctor came back who had been dispatched to examine the body, and he gave his deposition in writing. And the result of all of these interrogations and the police report were then summarized in a police report that is then forwarded to this thing called Majlis al-Ahkam, whose records I'm reading. Majlis al-Ahkam turns out to be a body of law that is at the pinnacle of a legal system that I want to talk about. It acts as a court of third instance. So there's a first instance court, second instance court, which is an appeals court, and this is the pinnacle of the Egyptian penal system, to which cases like this are forwarded. Majlis al-Ahkam looks at the cases based on documents. No, I mean, the interrogation took place in the police. Now they just look at documents and they come to a conclusion that based on the testimony of the witnesses and based on the interrogation record of Omar Wasfi, and primarily based on the forensic medical report of the medical examiner, we reach the conclusion that Sultan al-Abd, the slave called Sultan, had indeed been killed, been beaten, that the beating was excessive, that the beating caused an internal hemorrhage, and that this internal hemorrhage was the cause of his death, based on the forensic report. Based on this, we deem the case now is obviously a case of murder that, according to Sharia, they say, it can end up with either conviction or acquittal or the plaintiffs dropping the case and reaching and forgiving the killer. But according to us, siyasa, this is now a new term, not Sharia, but according to siyasa, which in modern Arabic means politics, but in this case, it refers to a complex political/legal concept, meaning state enacted law, the aim of which is to uphold public order. And they say, in this case, siyasa is operative, and accordingly, Omar Bey Wasfi has to be punished. Why? This is a language I have never heard in hundreds of cases I've read in Majlis al-Ahkam. They use the following words. They say, Omar Bey Wasfi تعدى وضيع حرمة الحكومة. He has attacked and squandered the sanctity of the state. And the state should avenge itself for his violating its sanctity. فالحكومة لابد من أخذ حقها منه نظير تعديه في هتك حرمتها. He violated the sanctity of the state. They forwarded this very strong recommendation to Said Pasha, the governor of Egypt, of all of Egypt, the king in a sense, the Khedive of Egypt, although he had not yet acquired the title of Khedive. And Said Pasha, when he received this recommendation, ordered Omar Bey Wasfi to be exiled from Egypt. And orders were sent to the port governors not to allow him back in. Now, what immediately struck me in this case is the following. First of all, the awareness of these enslaved men of the centrality of the police. They can actually go to the police to ask for grievances, to air their grievances against a very senior official in all of Egypt. These are 27 black slaves, let's call them the way they were referred to, Abid, who had the power, or thought they had the power, to bring a case against one of their masters. And not any master. He is the overseer of an estate belonging to the member of the ruling family of Egypt, who happens also to be married to the daughter of the Ottoman Sultan. Secondly, they show an acute awareness of the centrality of forensic medicine. They are asking for the forensic doctor to accompany the chief commissioner, the chief police commissioner of Cairo, to investigate the body of their dead comrade. And then they are also aware of the centrality of the legal system. There is a budding legal system that is not Sharia. It's not the familiar Sharia system that had been in existence for centuries. This is a new system of siyasa, where police stations play an important role. They know that this legal system is powerful in establishing the authority of the state, of al-hukuma, this hukuma that has a sanctity. And this is why this scene at the gate is interesting, because the Cairo police commissioner is an employee, موظف, of the new state that is being formed in Egypt. And the chief black gatekeeper is a gatekeeper of an estate, daira. And he's basically telling the official, no, you have no jurisdiction here. It's Ilhami, this is a private estate. You, a member of the new budding bureaucracy, have no right to enter the premises of the estate. And effectively, Said Pasha, the governor of Egypt, is giving up a member of his own family and the people working for his grandnephew and saying, no, what happens on this estate is not private, even if it pertains to a black slave. In fact, the murder of a black slave is an affront to the sanctity of my state. And I have to take revenge. I, as head of Egypt, not head of the family, I, as head of Egypt, have now found that my sovereignty had been squandered and violated by the killing of this slave. And I have to avenge him. Now, this was not the only incident in which forensic medicine played a big role, and in which lower class, non-elite Egyptians understood its significance. I can share with you many, many other cases. My book ends with another case. They all look the same, but this is another register, more or less the same time, a year later, of a woman called Mahbouba. It's a dramatic case that can be a subject of a movie or a novel. It's just amazing cases, these very, very dramatic cases. So Mahbouba, again, to summarize it very quickly, Mahbouba is a very poor woman who is married to a young man called Ali Gadallah. And Ali Gadallah is supposed to be report for corvée labor. The Cairo-Suez railway line is being constructed. Provincial governors are summoning and grabbing men literally by their necks to go and work in corvée to construct the railway line. And Ali disappears. He escapes. He doesn't want to go to this service. So the local provincial governor, who's named Muhammad al-Sha'rawi, is asked to go and find him. He goes to Ali Gadallah's house. He cannot find him, so he arrests his wife instead, Mahbouba. And in his custody, he beats her up to confess as to her husband's whereabouts. She says, I don't know where he is. And as a result, her case deteriorates. An assistant of his tells him, this is very serious. It's better that you release her because she's dying. So she goes home and she dies. At that time, her husband, Ali, appears. And together with his mother-in-law, that is Mahbouba's mother, they go and file a case in front of the Qadi. and they say, we want a medical examination. And Qadi says, this is not my business. If you want a medical examination, you go to the Siyasa. So they go to the Siyasa Council and they look for a forensic doctor until they found someone, a forensic doctor, who actually examines Mahbouba's body and says that she had died as a result of beating, and the beating had been delivered on her in prison. And as a result of the forensic doctor's report, Muhammad al-Sha'rawi was sentenced to 7 years in prison. So these are the cases I've been looking for. And maybe in the Q&A, we can talk about how I ended up being interested in this kind of cases in the first place and how I ended up finding them. And there are many, many, many cases. And my book is full of, these are the two dramatic ones that I love. I love Mahbouba's case in particular, but there are many, many others that I have found. 3 years after Sultan's case, specifically in 1861, Said Pasha passed a decree banning flogging. It's a decree that it's not known in Egyptian legal history, but I consider it to be very important. It's explicitly called لائحة استبدال الضرب بالحبس. The decree replacing beating by prison. And it basically banned beating. Now, I want to, in the remaining time I have, the half hour or so, explain this case, Mahbouba's case, and this decree. I want to start my examination by contrasting these cases, where beating is a serious problem and it is adjudicated and punished. I want to contrast it by a case 30 years earlier, literally 1829, where Muhammad Ali hears about one of his employees, the police commissioner of a small town in the middle of the Delta called Midgham, who beat to death a man caught forging official receipts. He ordered him lashed 1,800 lashes. The guy perished. What was the reaction of Muhammad Ali, the head of Egypt, the governor of Egypt, when he heard of this case? Nothing. He verbally reprimanded Saleh Bey, this police official. Nothing more. He didn't bring him to court. He didn't exile him the way Omar Bey Wasfi was. He didn't send him to prison the way Muhammad al-Sha'rawi was. So how can we explain this transition from a moment in the 1820s when violence was sanctioned to a moment 30 years later when it was banned and punished? How can we explain this transition? This is the question I was asking. And let me elaborate further. Some of the questions that I also found myself raising when I read these cases and many others. What is this hukuma? We take it for granted. What is this state? When was it founded? How was it founded? Who constitutes it? This transition from the estate to the state, this transition from a household government to a bureaucracy represented by the police. What is this police? When was it founded? And how was it founded? And most interestingly, this legal system that is called siyasa and the specific role that forensic medicine played in it. Who are these doctors? Where were they trained? What kind of medical expertise did they have? These are serious medical examinations. This is not just external post-mortem examination. These were cases in which autopsies were conducted in a central medical establishment that continues to exist till today, Qasr al-Aini, which is the Cairo University Medical School. Founded in 1827, this is where these bodies were sent, opened up, and examined in cases like this, where either epidemics are suspected or homicide is suspected. I found many cases of poison, of battery, of rape, in which forensic medicine played a big role in adjudicating them. The way I attempted to answer this question in my book is chapters 1 and 2. The first chapter is the medical system. Chapter 2 is the legal system. So basically what I'm interested in is the intersection of medicine and law, which is what forensic medicine is about. And not from looking at it from the point of view of lawyers or judges or doctors and nurses, but from the point of view of Mahbouba, of her mother, of Sultan and his fellow enslaved men. In other words, a non-elite perspective of the Egyptian state. How did average and less than average Egyptians understand the creation of this modern political, legal, medical system? So, to go back to my specific question, which is how do we explain the abolishing and the banning of torture and beating in Egypt? We have to, in order to answer this question, to understand what role did beating play in the legal system? What role did physical violence play in the Egyptian legal system? First of all, there was unofficial violence. And this was of serious concern for Muhammad Ali, the founder of modern Egypt, the founder of the ruling dynasty, the founder of the ruling family. Let me give you a couple of examples. Muhammad Ali had 3 sons and 2 daughters from his first wife. One of the daughters called Nazla. Nazla is married to, this is his oldest daughter, his eldest daughter, married to his chief accountant, Muhammad Bih al-Dafdardar. That's his name. She, according to family legend, Nazla was very much in love with her husband. She was jovial and gay and fun, but very, very jealous and protective of her husband. One day, she heard her husband comment on one of the female servants working in her household, commenting on her hair and her good looks. That same night, that same evening, over dinner, Muhammad al-Daftardar was served this slave's head. Nazla had ordered this woman to be beheaded, and she served her head to her husband. And when her father, Muhammad Ali, heard of this, he ordered her killed. He ordered his grandson, Abbas, to kill his aunt. And this didn't happen, but he was so horrified at what his daughter had done that his initial instinct is that we cannot tolerate this. Now, Muhammad Ali is not just a father. Muhammad Ali is a founder of a system, a founder of a modern state, and hence his reaction is significant. He had the same reaction with his grandson, this same guy, Abbas, who followed him as ruler of Egypt. He heard that Abbas, his grandson, had killed with his own hands his baker, Khabbaz. So he wrote to him, he said, What are you doing? You guys, you, my sons, my daughters, members of my household. Egypt would slip from your fingertips if you continue to act in this way. But nevertheless, he, Muhammad Ali, ordered his own son to go and kill with his own hands the chief accountant, Muallim Ghali, because this guy, Muallim Ghali, was opposed to a certain tax. And Ibrahim went and killed Muallim Ghali. Muhammad Ali had second thoughts and told him, we shouldn't have done this. Go and try and pacify Muallim Ghali's colleagues. What we are seeing here is members of the ruling family thinking that because they rule the country, they can kill with their own hands. Muhammad Ali realizing, because he is a statesman, that this is very dangerous, that their position in power can be squandered, and law and order can collapse as a result of this wanton use of violence. So this is unofficial violence. This is not sanctified. This is not sanctioned. This is not legalized. But beating was official in the Egyptian legal system. So Muhammad Ali actually did something that previous rulers of Egypt never did under the Ottomans. He enacted laws. They are called qanun. No previous Egyptian ruler did that. And specifically from the 1820s onwards. Muhammad Ali ruled from 1805 to 1848. Midway in his career, he started issuing qanuns. One of them is Qanun al-Filaha. It's a very important legal document passed in 1829. That law that governed the agricultural system, the planting of cotton, the harvesting, but also order in the countryside. That law had 31 of its 55 articles stipulated the use of the whip as legal punishment. The whip was something that the law stipulated. This was not something that was done outside the law. This is not an extra legal punishment. This was legal punishment. And subsequent laws had ample recourse to the whip. Laws that were passed throughout the 30s and 40s. But bit by bit, either the whip or the bastinado, a strong wooden cane that was used to beat people on the soles of their feet. Again, this is not extra legal. This was legal. The laws said whoever committed this crime will be punished by so many lashes. So this was tabulated, this was organized, this was stipulated in the law. The question, obviously, not only in Egypt, but with all kinds of punishments in the 19th century that used violence, is that there is so much meaning in beating. So I read so many letters, internal correspondence between government bodies, trying to quantify pain, trying to say we have a problem in quantifying pain. And also being very concerned with the meaning. Are we intending the onlookers, because these were public performances of violence, to intimidate the onlookers? Or are we trying to express the unlimited power of the Khedive? But more seriously, there's a concern that this beating may result in death. So a criminal who is caught, let's say, counterfeiting currencies or or forging official documents. This is a crime. The crime has a punishment in the law, and the punishment is, let's say, 50 lashes. It's not death. He's not been sentenced to death. He's sentenced to lashing. The question is, occasionally, as we're seeing, lashing results in death. So how can we stop this? So let me just give you an example of the language. So in 1830, the preamble of Qanun al-Filaha, I just read, cited to you, says the following: it has been known that convicted criminals are often beaten in an excessive manner. يضربون ضربا زائدا عن قانونهم. Accordingly, they may be seriously injured. يحصل لهم تلف. Therefore, it became necessary to specify exactly the punishment they are to receive. So they specified the number of the lashes, but who is to specify the severity of the lashes? Who is to specify the amount of pain? Pain cannot be quantified. This is why 30 years later, Said Pasha, the same guy who exiled Omar Bewasfi, passed a law and said to his, that says, beating in excess of the limit stipulated by law is contrary to our desire. And under no conditions should beating exceed 200 lashes. And very importantly, he says, quote, in this case, a physician should be present during the execution of the punishment. So there's an attempt to limit the amount of violence, but they can't. It's different, it's difficult. Also, what guarantees, I mean, how can we equate an old man receiving 50 lashes with a young man receiving the same number of lashes? Different bodies can tolerate pain differently. So how can we establish a standard uniform measure of pain? So I have read, ample documents, like ample number of documents expressing this anxiety. They sometimes refer to specific cases. They sometimes pontificate and reflect on it in the abstract. And the result of all of this is a desire to find a replacement. And the replacement happened to be prison. But prison, and this is a section in another chapter, had to have a different meaning. Prisons were not invented in 19th century Egypt. Prisons existed in Egypt since Joseph, the biblical figure. Egypt had prisons like any other country, but prisons were places of exile and death. People were sent to prison to die, to be forgotten. Prisons in 19th century Egypt were a subject of intense scrutiny. And there was a very careful, meticulous attempt to upgrade the medical services presented and provided in Egyptian prisons. My dear friend and late friend who passed away some years ago, Ruud Peters, Dutch historian of Egypt legal system, who did pioneering work in the archives. We met actually in the archives. He studied medical services in Egyptian prisons and came up with an amazing finding that showed the transition and the improvement in the Egyptian prison system. Mortality figures in the 1840s were high as 13%. That figure was significantly reduced to 4.5% in the 1860s. In over only 20-year period, the figure was reduced from 13% to 4.5% mortality figures in Egyptian prisons. So in that sense, prison could offer itself as an alternative to beating, as punishment. And this is the logic behind the 1861 decree that is officially called the decree replacing beating by prison. But beating played another role in the Egyptian legal system, and that was in interrogation, not as punishment, but as a means to extract confession. Again, this was not extra legal. This was official. This was public. This was known. This was not a secret that the Egyptian authorities were embarrassed of or embarrassed by and tried to hide. No, it was something that was performed repeatedly. But as in modern times, only the people performing this and being intimately connected to beating know very well that very often innocent people confess to crimes that they had not committed, leaving the real culprit undeterred and unpunished. In other words, beating produces its own truth that is not really valid. So, and the question is, well, what can we do as an alternative? What alternative can we find to replace beating as a means to establish legal proof? That is where forensic medicine steps in. Forensic medicine provided itself as a new expertise that can establish probative proof in front of the legal system. But it's a new legal system. It is not the Sharia courts. It is now these siyasa majlises, these siyasa councils that would adjudicate cases based on all kinds of evidence, including written, not oral, written reports presented by forensic doctors who can establish a cause of death and who can establish a causal link between beating and death. So in the absence of witnesses, which according to classical fiqh in Sharia, the case would be dropped with no witnesses or confession. But with forensic medicine presenting itself as a circumstantial evidence, not as the classical Islamic Shari means of incontrovertible truth provided by witness testimony or a confession. Now the written reports of forensic doctors establish themselves as a reliable means of establishing legal proof. So this is, I mean, we can talk about, if you want, the difference between the kind of medical expertise that the Sharia court used to accept and the kind of medical expertise that the new councils in Egypt in the middle of the 19th century accepted. So in conclusion, what we see here is a new legal system in which forensic medicine played a key role. And this forensic medicine was so visible and its importance and centrality was so obvious that people like Mahbuba's husband or her mother or these 27 slaves could immediately understand and demand and ask for in order to bring justice. Secondly, interestingly, this medical expertise was presented to these new established bodies not in an oral form, but in a textual form. And that is a very significant, it's not a small, it plays a very big role in my understanding of what this new bureaucracy was all about. These siyasa councils that accepted evidence presented by forensic doctors, it was their role, not the limiting of fiqh to personal status and family law that led to the secularization of the Egyptian legal system. In other words, in my mind, it is the textualization and bureaucratization of the Egyptian legal system that lies behind its what we call its secular aspect, secular characteristic. And thirdly, now we see the state, this hukuma, represented by the bureaucracy and by the police and by these new councils, that is now monopolizing violence and ultimately giving it up. The state snatched the proverbial whip from the hands of its officials and replaced this whip by prisons. At the same time, non-elite Egyptians understood the role that law and medicine played in the new state and came to expect that the new police and the new Siyasa courts would permit them to gain justice using these novel modern techniques. Thank you very much.
Thank you, Khaled. This was really mind-blowing. Great.
Oh.
Do we have any questions? Huh?
One online.
We have one online. Okay, but shall we start? Okay, since the questions online are here. Okay, I have a Zoom question as we get to accept others. So questioner is Katrine Marji. She's of our team as well. Based on the reading and your lecture, Dr. Fahmy, I was fascinated by how these enslaved men turned to the law and to forensic medicine in their pursuit of justice. What inspired you to focus on cases like this in your research? And how do you approach the challenge of uncovering and interpreting the voices of marginalized groups in the archives?
Thank you. This is a wonderful question. Well, you know, let me share with you a personal, my personal reflections and memory of this. I still remember the day I read this case, the case of the 27 enslaved men, the case of Sultan al-Abd. This is how the case is known, is referred to in the document, Sultan al-Abd. I still remember it vividly. I was so shaken by it, because the details are horrific. I mean, I spared you the details of what happened to his body and the description of the beating and how he died. In the case, it took me, reading a case like this, understanding it, reading it line by line and figuring it out, this, can take an hour. Just, reading, taking notes and comprehending the gravity of it. And my very, very good friend, my best friend in Egypt, Reem Saad, anthropologist, I was so shaken. I was going to Reem's house after the archives, and I would pass by the Coptic Patriarchate. It's on my way, which is where the estate used to be located. So I started thinking, oh my God, this is where this incident happened. So I was so shaken. I went to Reem's house, and Tantu Ded, her mother. Those of you who've witnessed, who've watched For Women of Egypt, this amazing movie, Tantu Ded Mitri, that's her mother. She greeted me. She saw me being shaken. She said, Khaled, what's wrong with her? So I started telling her what happened, but I forgot to tell her that this is something that I read in the archives. She said, what are you talking about? Where? What slaves? Which bay? I was just so moved, so agitated, so disturbed by it that I forgot to tell her that this is something that happened 150 years ago. And so I mean, this was a turning point in my research. This chapter this case comes in chapter 5, the last chapter. But in fact, it is what started the project in the way I'm telling you. Like I said, okay, this is serious, guys. I kept on telling myself, this is a serious case. There's something very profound in it. And I need to pay attention. I need to know. And it took me 15 years of poring over documents the way I described. Okay, I know the details of the case, but who are these doctors? Where were they trained? What is this Qasr al-Aini? What is this legal system? What is this siyasa? What is its connection to Sharia? How did it evolve? And how did people react to this? How did they understand it? I see them saying something. So the question obviously is, it's a question that people who work on Sharia code documents also ask. It's a question that any historian asks about her sources. What is this? What can this tell us? This is something that is written by the state. This is something that the scribe sitting next to the Cairo police commissioner wrote. To what degree, this much we know. But what else is not here? What other cases were lost or not recorded? To what degree can we be sure that what Bekhit says, who had the bead of 99 habba, the sibha with 99 beads, actually say what he said? Are these actual words of these enslaved men? They are accused of all kinds of things by their master. They answer back. The question I think that you're asking is, to what degree can I be certain that this actually is what took place in the police station? That this is actually what these 27 enslaved men said. There are some people who say that these sources are opaque. They say nothing but what is written on. We cannot go beyond that. We cannot surmise what might have been taking place in the minds of these 27 men using what they allegedly said. In other words, there are people who say that these sources are sources only of the state, and we have nothing but to deconstruct the language therein to find out what the authors might have meant. I see the logic of this kind of reasoning, but I find it inadequate. I find it also politically irresponsible. I have a feeling that, yes, this is not the voice of Sultan or his comrades, but there is something about what they did, as far as it is recorded, that is indicative of their agency, their mindset, their life. It's not explicitly clear because this is not the letters that they wrote to their loved ones, assuming that the letters that they might have written to their loved ones are indicative of their inner feelings. These are documents of the state. These are documents of power. These are documents of authority, even if they claim to be recording voices of the marginal and, in this case, enslaved men. That is true, but I still find that dismissing them completely as nothing but voices of power to be squandering a very precious source of information about people who are not in power. And the trick or the challenge is to try and read between the lines. It's not to read the lines, it's to try and deduce what is not said. To try and, for example, I have a section in the book to trying to tease out notions of justice that are contested in a case like this. Omar B. Wasfi uses the word adl and hukuma, justice, الحق. He says, الحق إقامة الحق من وجوب إقامة العدل من وجوب الحق, or something like this. He uses حق and عدل and hukuma. These enslaved men are quoted to say the way he is quoted. I mean, we don't know what he said. We don't know what they said. We have what is recorded in this document. And in this document, there are contested versions of justice. But it's not only this case, it's repeated cases, and I think the idea, I was fortunate enough not to go for 1 year to the archives. As I told you, I've been to the archives for a totality of 15 years. Some years can be only a week, depending, because I used to teach in the US and I would go on my vacations to the archives to do research. Sometimes a whole year I had a sabbatical in which I spent it in its entirety in the archives. But over these years, I've consulted so many letters and so many documents, and there comes a moment after a while in which it's not a document you find, it's a feeling that you get. Now, this is of course not scientific, but I'm telling you frankly, this is when you start feeling something, you say, okay, I've read so many cases, I can see where this is leading. I'm not learning anything except an intuition that something is motivating the authorities, something is motivating these enslaved people, something that is motivating Mahbouba's mother, to seek something. My book is called In Quest of Justice. It's a quest that I detected. It's never written, it's never explicitly stated. But it's repeated acts in so many cases that I found that I considered them to be a challenge to me to take them seriously. So to come back, and I will end by this, to come back to this feeling I had when I read this, when I went to Reem and told her mother what I had just been reading, I remember distinctly feeling at that time that I am being challenged. I understand what I had read on a certain level, but there's so much that I'm not understanding that I need to unravel. And that took me many years. So the question is to accept the challenge and to try at best to give these people what I think they deserve in terms of attention and respect. So that's my way of handling your very important question.
More question. Yes.
So I recently read a book that was about contention between Sharia, the modern Egyptian legal code, and organ transplant in Egypt. And I was wondering if the book specifically talks about the violation of the sanctity of the body and divine determination. And I was wondering if any similar vein of contention appears in forensic medicine in Egypt, specifically in the context of modern autopsies.
Thanks. I think I know. Yeah, I know what you're referring to. No, in my case, I didn't find this. I didn't find. So my case, look, this is the cover of my book. And it's a painting that is in the medical school museum. It's a museum inside the Qasr al-Aini Medical School in Cairo. And it's a painting depicting supposedly the first dissection lesson in Egypt. What we see is a dead body here being dissected. And this is the chief doctor, who happens to be a Frenchman. His name is Klobbe. And surrounding the whole scene is these turbaned, these are the students. And then these are religious men, men of religion, who, according to this painting, stand in between the body and the students. The body, which is the source of knowledge, and the students. And they also partially obstruct our own view as viewers of the painting. This painting is a piece of ideology. This is not an honest painting. This is a political statement. This painting is done 100 years after this incident took place. This painter is a Russian painter who lived in Egypt in the 1920s. And he based his painting on the memoirs of this guy, Klobbe, the French guy. It is Klobbe who made this argument. I am a man of science. I'm a man of rationality. I'm civilized. And I'm coming to this backward barbarian country to enlighten these barbarians. And in my attempt to bring civilization, I am hampered by these religious men. Islam is an obstacle to science. But because I have been employed by the enlightened ruler Muhammad Ali, and because I also myself am enlightened, I managed to overcome their superstitions and their resistance. This is nonsense. I have found no evidence that any person in the religious establishment in Egypt made such accusations or such hostility or opposition to dissection. Mahbouba is a Muslim, and these enslaved men are Muslim. Omar Biwasfi is Muslim. The question is, what is Islam? This is, excuse me, the argument of Shahab Ahmad's book, What is Islam? And Shahab Ahmad is telling us Islam basically is what Muslims do. It's not only what the ulama say. So what I have found is an Islamic system. This siyasa system is not imported from France. It is something that evolves out of the Egyptian legal system. And it's not a 19th century invention. Sharia, fiqh, has always been coupled with siyasa since day one. What is interesting about my case is that we now finally have the documents of a siyasa system that have not been preserved in other archives. But more to the point, when dissections were first introduced in Egypt, the problem was not what Islam would say. The problem was where to get the bodies from. When 100 years later, when the question was posed in an istifta, an official legal question presented to the Mufti of Egypt, who happens to be Muhammad Abdu, asking him, no, it was Rashid Rida, sorry. It was in Al Manar newspaper. A question was received, what's the correct, what's the, is autopsies and dissections licit or not? This is in 1911. And in the response, in the fatwa, he says, autopsies have been performed in Egypt for nearly 70 years. And they are listed for the following reasons. First, for medical education. And second, for catching epidemics. And third, for catching homicides. But way before then, way before this fatwa in 1911, one of the medical doctors who had been sent to France, his name is Muhammad al-Shabasi, and came back to his alma mater, to Qasr al-Aini, to teach in it. He published a book, I forget the title now, in the late 1840s. It's a book on forensic medicine. It's basically a textbook on how to perform dissections. But the introduction, in his introduction, he asks this specific question. What are we doing with this new practice? Is it contrary to or contrary to the precepts of the faith or not? And he says it is not only necessary to medical education, but for the execution of Sharia. And he provides the following example. He says, what do you do in a case of a family of 10 people who live together in the same house, and the house has an accident? It collapses on them, and they die. The question of inheritance, which is a question of Islamic law. How do we divide the inheritance? We cannot divide the inheritance except if we know who died before whom. This is a question that only a forensic doctor can answer. So forensic medicine is important to uphold the principles of the faith. Secondly, another example. He's talking to his students, to the readers, the intended readers of his book. He says, you are a forensic doctor. You walk down the street and you see a dead body. You have to be very careful in examining it and conducting a post-mortem examination on it. And if need be, and in case of doubt, you send the body to a hospital for an autopsy. Why? Because if you are negligent and not careful, and you declare this to be a case of natural death, when in fact it had been caused by another person, in other words, when it is homicide or manslaughter, you would have forfeited the right of the next of kin for qasas, the Islamic Sharia principle of talion, of asking for the life of the killer. And then in the same sentence, he adds, you would also have then wrongly characterized this case, and it will be wrongly entered in the annual statistics of the state. Why? Because, and this is something I have studied also, this is a modern state. It tabulates every single case of death. This is how epidemics were caught by statistics. So the rightful, correct characterization of every cause of death is what modern states do. So in the same paragraph, he mentions the logic of the modern state, the logic of modernity, and the logic of fiqh when it comes to tali and qasas and homicide. There's no contradiction. So the idea of, and then in classical Islamic, in fiqh, Ibn Qudama in Mughni, Hanbali faqih, when this question was asked in pre-modern times before dissection, was asked in the following manner. It's all hypothetical. These are not actual cases. These, like all fiqh questions, are hypothetical questions to uphold legal principles. So the question is the following. A thief who has stolen jewelry is caught red-handed escaping from the house with the jewelry in his hands. In order to hide the evidence, he swallows them and then dies. Does the owner of the jewelry have the right to open his belly and extract the jewelry, or should he be compensated in a financial way? The other example is a pregnant woman who dies in child labor, but we can still hear the fetus alive. Do we have the right to open her belly to extract the fetus, or is this against the sanctity of the body? It's these kinds of examples that are mentioned by pre-modern fuqaha, and in general, their answer is, if opening the body can save life, then we open it. If we can save the life of the fetus, then that takes precedence over sanctifying the body. So this is a thorny issue, but in the majority of cases in pre-modern times, they gave a positive answer to this question. And in modern times, when the benefits of medicine had already been, of dissection had already been proven in practice, the muftis refer to it. They say, we defer to what has been taking place. And dissection is useful, is licit because it upholds the principles of the faith.
Correct, Khaled. Thank you so much, Khaled. We really appreciate your thoughtfulness and your great presentation and answers. We have to call it in, and I'm so glad that you were able to join us.
Thank you so much, Khaled. It's been a pleasure. Thank you very much for the audience.
Appreciate it. Thank you. Assalam.
Assalam.